Shamsi, have we met before? I feel like we've met a long time ago. I've been here for about 14 years.
I've been in and out of Woodstock since '94, so it's
Okay.
probably,
It's probably, but hi, how are, well, nice to see you again. Or
nice to see you too. I have a guest coming and she's gonna sit in if that's okay.
Oh, sure. Yeah.
Okay.
Yeah, it's open to the public, so it's fine.
Hi. Great, okay.
Hey, Rob.
Hello.
How are you?
I'm good.
Good.
I love you, Zoe. You're the best dog. And my mask, my brother.
You the new police chief?
I'm the chief.
Okay. We can turn out the light. Shut the door. Don't
That's
bother
it.
us.
That's right.
If he doesn't know what he's doing, he's lost. I had to help him figure out how to correct a document.
Well, he's getting there. He's getting there.
Spelling what? Now, you would think that it was written by the supervisor secretary. You would think the supervisor secretary would have known how to correct it.
You would think.
You would think. Well, I had to help him. All right, see you later, Rob. Bye,
Bye.
Michelle.
Hey, Ray,
Yeah.
do you know how to load the presentation onto Zoom?
That's an Ashley question. I thought you were going to share your screen.
Yeah, I want to do that. I have the presentation on the desktop. I just got to get into here, onto Zoom.
What you'll do is you'll pull it up on your screen because you'll have a share screen button on for Zoom. And then once it's on your screen, that will, as you click through, you'll,
Oh, I see.
We'll see. Right.
You see?
Yep. Exactly.
Right.
Perfect.
Hi there, Reggie.
Hey, Chief.
I'm here. Hi, Ashley. Everybody else?
Hello, Chief. How are you?
Good. Good. So do you want to turn that computer so?
I know Rachel will be here. Anula should be. Vanya. John won't be here today.
Turn that volume up.
Yeah. There's Rachel. There's Maria Elena. And Rachel. Anula. There's Anula.
Hi, everybody.
Maria, Jessica. Hi. Just want to give Vanya a couple minutes and then we'll get started. Just want to step away to text her real quick.
Does Reggie see that?
Yeah, they all see this. This is isn't it shared. See everybody's face here. We have shared.
Okay, and I think Vanya's here too. Okay, great. So we can get started. So hi, everybody. Welcome. A lot of new faces from the public. Thank you for being here today. Today, we're going to have Officer Robert Giacchitis from town of Woodstock, from our own force. walk us through the use of force training that he teaches. I'm going to have him talk about that process, about where he teaches and how long. But he's going to be walking us through that for basically the hour and a half. What I'd like to ask the members to do is to write down your questions as he's giving his presentation, because he'll be back with us to wrap up next week and to answer all of our questions. He'll also be answering questions we have around the policy that Chief Keefe sent to us a few weeks back. So since he teaches that, we thought he would be a good source. So, and members of the public, if you have questions, if you would put them in the chat box, and I would just ask Ashley if you would make note of those questions around the training. And then next week, we'll read those questions from the public, okay? So Officer Jakaitis, I'm gonna ask you to.
Okay, the presentation I have here is the one I use for instruction for police in Ulster County and Columbia Green. The 100% of this presentation, 95% of this presentation, because I have a couple things, is really taken off of almost verbatim the policy is for the state, for Department of Criminal Justice. So we'll discuss a few things. I'm going to skip the videos. Give everybody a copy of this. That's not a problem. If you want to watch the videos, that's fine. But it'll take quite a while. Today, this is a 2-day training with this presentation. I'm going to try and call in a couple hours. This is going to cover everything from physical force to deadly physical force and the workings of it and how we come to these conclusions, or how the state comes to these conclusions. I'm in no way, shape, or form an expert in use of force. I do a lot of research with it. I bounce a lot of questions to police chiefs in Ulster County, and we follow the guidelines presented to us for the state. So typically I'll start with our objectives, which is the describe the balance between police authority and responsibility pertaining to use of force. Next, we'll move on to defining what physical force is, what deadly physical force is, what serious physical injury is. Recognize circumstances that justify the use of physical force and the use of deadly physical force. Recognize conditions and consequences associated with the use of physical force and deadly physical force, and describe the relationship and differences between federal law and state law and agency policy regarding use of force. This is strictly right out of verbatim, right out of the state's requirement. And we'll discuss Article 35. Article 35 in the state of New York is use of force. That's what it primarily is. Also added to use of force now is life issues. And when they mean priority of life, they're talking about officers in contact emotionally disturbed and how to better handle that. They sort of lumped it in with also mental health training and other new trainings that the academy teaches with regards to disturbed, disabled as well, and rules regarding physical force and deadly physical force. They describe the balance between authority and responsibility pertaining to use of force, and the topic has created public discussion or garnered more media attention in recent years in the discussion of how police use force. Police agencies in the U.S., approximately 17,000, almost 18,000. Police killings in 2018, almost 1,000. That's kind of been staying the same for the past few years. Police officers killed in 2018, 48, and that fluctuates a little bit. And police face-to-face contact is in 1 year is 58 million, and that's throughout the country. You would think it'd be more. The founding father of policing is Sir Robert Peel. And Robert Peel had 9 rules in which to police by. And number 6, as you see here, is use of physical force. And this is his words verbatim, to the extent necessary to secure observance of the law or to restore order, the exercise of persuasion, advance warning found to be insufficient to achieve police objectives. Police should only use minimum amount of force which is necessary for achieving that objective. That hasn't changed since he came up with his 9 rules. And to focus on these principles was to outline fundamentals of police force that serves the public by the public's own consent. This is the way that policing in the modern world is conducted today. Should be conducted today. Before I get into detail, I'll typically talk about discussions regarding use of force. What are some of the definitions out there? Justification defined under Article 3505 is a defense to an offense. An individual admits that an offense has been committed, but at the same time asserts that it was committed under circumstances legally justified the action taken. Now, an offense to an offense, meaning that I am committing an offense, essentially I'm holding somebody, which is an offense. Why am I doing it? Is essentially what that kind of means. The choice of evil doctrines still on 3505. That's the individual legally constitutes an offense, but in taking that action, the occurrence of greater evil was preventing. And back to, prevent. It's like that's the old breaking into somebody's house to use a phone, let's say, to call 911. Is it illegal to break in? Is it illegal for me to grab somebody and stop them from committing a crime? No, I can. I can physically hold them. Is it a crime to hold them? Yes. So that's preventing something bigger from happening. Necessity, the requirements that of physical and or physical force should only be used where reasonably believed to be required to accomplish a lawful objective. And these laws are not just for police officers in Article 35, they're also for their citizens, that they do have to follow these same rules. There's some differences as you get further into 35 as to what citizens can do as opposed to what police officers are required to. Reasonable cause to believe exists when evidence or information which appears reliable discloses facts or circumstances which are collectively of such weight and persuasiveness as to convince a person of ordinary intelligence and judgment and experience it is reasonably likely that such offense was committed and that such person committed the offense. And that's Penal Law 7010, except otherwise provided in that chapter. Apparently reliable evidence may include or consist of hearsay. And then probable cause, the purpose for warrantless arrest. I mean, all the facts you gather together brought you to probable cause to say that this is the person that 90% has probably committed that offense. Deadly, and then going back to Article 35, your physical force is physical force under circumstances in which is used to readily capable of causing death or serious injury. Physical force that does not amount to deadly physical force, and serious physical force is it causes substantial risk of death for protracted disfigurement, impairment, health, or protracted loss of impairment of the function of that bodily organ. And then physical impairment of a physical condition of substantial pain. I'm going through this. To teach it, I'd have to bring down, and it would take a lot of time, but there's better stuff. I know I'm just getting through definitions right now. We all know what a police officer is. We all know what a peace officer is. The big one here is objectively reasonable. This is where it starts to get into kind of the meat of it. A standard used to judge an officer's action under this standard, a particular application of force must be judged through the perspective of a reasonable officer, facing the same set of circumstances without the of hindsight, and be based on totality of facts. When it comes to objectively reasonable, it really comes down to the totality of facts that are known to the officer at the time that the force was being used. What are some of those facts? When they come to objective reasonableness, they kind of break the standard. And a case back in '89 where a guy pulls up in front of a convenience store, and there's also a passenger in the car. The passenger gets out and runs the store. He runs in the store. Now, an officer across the street is observing all this. As he bolts into the store, he runs out of the store, jumps back and take off. They take off fast. The officer follows them under reasonable suspicion that something is afoot here. Something's going on. We don't know what it is yet, but something's going on. And this is a Graham versus Connor. And what happens was he ends up stopping the car. And when he gets out of the car, he approaches the car and starts talking to the driver for their information. The passenger then gets out of the vehicle and he starts running around the vehicle. And he makes like 4 laps around the vehicle before the officer stops him and then puts on the ground due to the fact that now he's becoming a hazard to the public and to himself. So he puts him on the ground and he's putting him down. At this point, more officers are showing up. Based on what the officer knew back then, based on what the officer knows is that he doesn't know, he thinks the person's intoxicated and he's trying to secure him. The guy is really becoming resistant. And the 3 officers there end up picking him up. They put him on the car, they cuff him up, they put him in the back seat. At this point, the driver of the car says, he's my friend, he's suffering diabetic emergency. He needs to get sugar. Now, it took, I don't know, roughly about 15, 20 minutes to figure out, hey, you know what, this guy might be suffering from a diabetic emergency. And they end up getting him orange juice. He drinks the orange juice. So the cops, in the meantime, are questioning the driver and said, well, why'd you go to the store and come back out? And he said, well, because the line was too big inside the store. That guy ran back out and jumped in his vehicle and they took the vehicle and took off. So what ended up happening was they obviously took the guy back out of the car, they uncuffed him, he started to feel better. I mean, at that point, in today's world, we would have sent him to the hospital. He wanted to go home, they took him home and they released him. There were some other issues with that. He got scrapes and bruises. Another big one was he broke his leg in the process of wrestling around. Well, he then saying that his civil rights were violated. It goes all the way to the Supreme Court. The Supreme Court decides that based on the objectively reasonableness of the crime, that the officers were exonerated from it because they were dealing with at the time. So that's where a lot of this objective reasonableness comes into play. It really is based on a couple of things. The biggest one being the totality of the facts known to the officer. There's some other ones that I jotted down, is that from the perspective of a reasonable, and they say reasonable, I say reasonably thinking officer, on that scene, what he reasonably saw at the moment that was used. Without the hindsight of 2020, they have that. They don't have that option. In circumstances that are tense and are uncertain and are rapidly evolving. To this day, all that gets taken into consideration when it comes to how do we move from physical force to subduing somebody, to taser, to OC spray, to batons, to deadly physical force. These are rapidly moving situations that maybe not all the facts are there. And there, this standard came into play. More to it, and we'll talk about it here. Seizure is a termination of movement. Meaning to say, I hold have you, that is considered to be, it's you're no longer free to go until we gather more information or make an arrest. Indemnification is security against personnel who legal responsibility to an agent to protect someone or from an entity from loss or damages, what moves us into qualified immunity. And that's been another buzzword that's been talked about recently. To have liability on the Fourth Amendment, officers must, one, violate a constitutional right, and two, that right must be clearly established in law. If the case against the officer cannot be clearly established in law, the officers then, the courts then, officers will be granted qualified immunity. Again, this is New York State's rule. Violate the constitutional right by obviously something happens that the officer does, but the thing is that it really comes down to the plaintiff to prove that the officer did something wrong. So it must establish the undertaking was done in good faith. That's another one to consider. Was the officer's actions done in good faith? Meaning to say, he may not have had all of the facts, and there's an interesting case I talk about in here where that comes into play. Need to hold public officials accountable when they exercise power irresponsibly, which was this 1967 case where they went into somebody's house, police officer, not quite sure what city, and they ordered everybody to stand at attention while they searched the house. That's irresponsibility, and that's where the officers are held accountable for their actions. And a bunch of others. I'm just using that as an example. Need to shield officials from harassment, distraction, and liability when they perform duties reasonably. And that one's in there as well. Qualified immunity is that when an officer does violate that constitutional right, it's clearly established in law. The plaintiff doesn't come up with a reasonable grounds, then that officer has to be shielded from the harassment, distraction that they could legitimately on the road. I can spend an hour talking about Ferguson. I actually going to put different cases now instead of using Ferguson. My personal opinion is that it was a numbers-oriented police agency, which numbers-oriented police agencies do not work in today's police world. Absolutely not. And there was a bunch of things that went wrong with Ferguson that we for another day. This is kind of what Darren Wilson did. Up to the shooting. In this case, recognize those people. Are you guys still there? Are they still there?
Yes.
Reggie?
We're here.
Oh, good. You're still
Yeah,
there. Thank
we're
you.
all muted.
Thank God. I thought I lost you.
We
Okay.
we're still
Just
we're still here.
While we're stopped, real quick, is there a way to share the PowerPoint or the link? I mean, even
Can I
if
share it?
Yeah, is there a way to share it in the chat box?
Yeah. Everybody's not seeing it?
We're seeing it, but it's very difficult to actually like we're following along, and some of us would like to actually take a little more time to be able to look at
Gotcha.
it. And I actually am receiving messages of people saying they would like to look at it as well. Yeah.
So is that possible to share that now, or would you have to share it? Could you share it afterwards? If you can't do it this second.
Well, I actually put on to share.
No, she said we can see the screen, but just saying that so folks could look at this afterwards.
Yeah, absolutely. Sure.
Okay. So would you be able to do
Yeah, I
that
can.
now?
I'll send it to everybody.
Okay.
Wonderful. Also, we're here. We've just been asked to hold all comments or questions into the chat so that you can just flow. So that's why you might feel alone at the moment, but we are actually.
We're all here. Yeah.
Okay.
Okay.
Okay. Yes, absolutely. I can definitely give you a copy of this.
Okay. Thank you.
This was through the Eric Gardner case. From start to finish. We know Eric Gardner. Again, I would end up talking about this for a while. This was the Amanda Geiger case in Texas. This was a pretty good case here. This is Roisin versus California in 1952. And this is what the phrase conduct that shocks the conscience. How this case unfolded was Roshin was on parole and he wouldn't have any narcotics. And what had happened is San Francisco cops got a tip for his drug activity coming from his apartment. So up with a probation, who obviously can go in, and when they open the door, they see he swallowed 2 capsules. They were actually morphine pills. And what they ended up doing was they put him on the ground, started jumping on him. And then they brought him to the hospital and ordered the doctor to pump his stomach, which he did. And he was forced to vomit, and they ended up getting the pill there, and then they charged him with it. Anyway, that makes it, again, another one that goes to the Supreme Court, and the Supreme Court said absolutely not. You're not going to jump on somebody and send them to the hospital and force them to vomit. So conduct shocks a conscience, and this bounces into as well when it comes to like vehicle pursuits, which is a different topic, but it sort of goes into that. Anything that is just so outrageous without being held accountable for it. And this was 1952, and those officers ended up losing their job. Rightfully so. Describe the balance between police authority and responsibility pertaining to use force. Why do police use force? These are the reasons why they use force. They need to establish control of a situation, first and foremost. It's to protect others or themselves, make an arrest or effect a detention, defend property, prevent the destruction of evidence, and to prevent escape from a prisoner. These are the 6 prime reasons why police use force. The balance, I can still with the balance. Why do police use deadly physical force, defense of others, and also self-defense? Where do police get their authorities to use force? The United States Constitution and the New York State Penal Law. Standards. Police officers are empowered by the government to enforce on a person prior to judicial review. This does not mean, of course, that they are rules that govern how much force can be used. Under Article 35, it provides that defense for justification that these rules that officers abide by. Conduct is excused, otherwise constitute an offense under state law, and police officers, where acting properly in their fees, are covered by that Article 35. If you have something other than that, meaning to say you have a civil rights violation, Title 18 under the federal code makes it a crime for a person acting under the authority of law to willfully deprive a person of a right or privilege protected by the Constitution. The right to be free from excessive force by charges will be brought by the U.S. Department of Justice. Civil rights violations. That's where you see a lot of these civil rights violations where maybe the cop's exonerated of a criminal, but it doesn't necessarily mean he's going to be exonerated of civil rights violations. So that's where they kind of stress this to the recruits that, you know, just because you're exonerated criminally does not mean you're going to be exonerated from civil rights violations. And then we talk about evolving where some of these, one in particular stands out was Shaver. I'm not sure if any of you know the Shaver case. That's a New Mexico, Arizona case. I don't know, maybe you saw it actually in the presentation. We kind of talk about it where this guy ended up getting shot by the emergency services team, where he was just crawling down a hallway as they're trying to call him to them. He ends up getting shot, and the cop gets exonerated criminally based on policy, but it bounces back to a civil rights violation where they are definitely going to pay out for that one. And this is why the policies have to be written a certain way. It's why use of force policies have to be written a certain way. It's to protect the people, number one. It's to protect the agency. It's to protect the officer from some officers not doing the right thing, to where in a situation like that, the agency may be held liable for that one because of certain things that were not in their policy. And for a lot of these civil rights payouts come, it's because it's not so much that the officer is really to blame for it. He's just following what the policy says. And then there's civil torts. Those who suffer from a civil loss or injury due to another person's wrong. If there's a legal duty between the defendant, law enforcement, and plaintiff, existence of a legal duty, a breach of duty, or damages, but for the breach would not have occurred. Again, if an officer breaches a duty, meaning we're required to act, we have to act. And now the other one that's now fairly new, which I think is fantastic, it just came out from New York State, was if there's a breach of duty and another officer sees it, they're required to document it, that this other officer did something wrong, or else they're going to be held liable for it. Elements of a special relationship, how municipalities can be liable. The assumption by the municipality through the actions of an affirmative duty of care on the behalf of the party who was injured, knowledge that action could lead to harm. I mean, they know that, and direct attack between the municipality's agents and the injured party at the party's justifiable reliance of undertaken or duty to act, meaning they'd say the municipality can be held liable for that officer's action and the fact that it's not clearly written in law, unless the officer does something completely off the law. If it's not clearly written in their policy, the agency is held liable for it. Objective reasonableness, talked a little bit about that before. It provides a relief for the plaintiff, constitutional protection under the color of law. It's as big in its claims. Claims of excessive force violation memory protections while being arrested or stopped. He may be named as a defendant by nature of, as I mentioned, practice or custom. Officers themselves face personal liability, and the officer may be qualified immunity as a shield, as I mentioned before. It allows reasonable mistakes on the legal constraints of a particular police conduct. And could an objectively reasonable officer believe circumstances that the conduct is lawful? If yes, then a summary judgment or matter of law, the officers appropriate. As I mentioned before, it comes down to the defendant to come up with object unreasonable. Does this mean that the conduct was correct? It means that the right that was violated was not clearly established. Rights are violated. A couple of cases that I put in there. Connor, we talked about White versus Paul. And again, this White versus Pauley goes back to the qualified immunity. If White versus Pauley, there was a erratic operator, and what had happened was it was this Pauley guy, and it was called in by a motorist, and they got a plate number, and the plate came back the address, and the white part of it was this Ray White, I think his name was, and Ray stated these women's statement, and there was two other show up his address. They pull in a driveway. They flight to the house. They say, you know, the place surrounded. Inside the house, then say, we have weapons here, property, and one guy goes out back. He fires a shotgun in the air a couple times. Back in the house. At this point, White shows up. He took statements from the girls. He shows up at the house. He doesn't know what has transpired yet. He then takes cover on the side of the house. And what had happened was this one of the Pauley guys, they were brothers, he points a handgun towards the officers. White ends up shooting him, killing him. And then what had transpired after that was it bounced back to the objective reasonableness with the qualified immunity. Did he know once he got on scene? Based on was evolving and evolving rapidly, and he sees a weapon come out of the house pointing at us, intent to use it, he took action and was not held liable for that. Tennessee versus Burr, that's a big one in use of force. It's been there for this happened in '74, and it was a case that really changed how Article 35. And in Tennessee versus Gardner, a neighbor, not sure what town it was in, called in a burglary complaint, said they heard glass breaking in the neighbor's house and knew that the neighbors weren't home. So the cops rolled up, they take the call, they roll up, and as they start to go around the house, they see some bolt from the house. And he makes it to the fence, he starts to climb the fence, and the officer shoots him, actually shoots him in the head. Back in 1974, that was justified. That's a justified shooting. That has since changed because of Tennessee Gardner, meaning to say Gardner left the building, and what did he steal? A pocketbook with $10 in it. Was Gardner a threat to society? We don't know. We know what we know what we know. We don't know if he is. We don't know if he is or isn't. Based on how it rolled out back then, that was justified. Today, no, absolutely not. You need to gather more information. I mean, to say he jumps the fence, a reasonable officer is going to follow him, try to subdue him, and that rolls out today. If you look at Article 35, wide, there's a lot of gray areas in it when it comes to you and the chief about this one earlier. If I'm burglarizing a home and exiting the window, am I justified in shooting? Under Article 35, the way it's written, yeah, sure, you're justified. But based on the way use of force is written, not. Unless the guy poses a threat to the officer or to somebody else. That's how it's written today. And it's been written like that for a while. McDonald versus City of Chicago. That's Laquan McDonald. Laquan McDonald was an EDP, emotionally disturbed person, who was walking down the street with a knife in his hand. And what he was doing was just scraping cars with a knife. He ends up on a highway in Chicago, and there must have been 9 units there. He's in the middle of the road. McDonald was a cop, ends up shooting him. Not only shoots him, but shoots him multiple times when he's on the stand and they're questioning him. And he tried to implement his qualified and his objective reasonableness to the crime, that he wasn't dropping the knife. Now, the way it's viewed, he ended up getting time. I think he ended up with, I want to say he got 7 years for that. So he did go to jail. If this same case came up 10 years ago, I honestly believe he would have been exonerated of it, but not in his world. There used to be an old saying out there that I used to use where I feared for my life, and they really abused it, in my opinion. And which is why I'm glad that these rules have changed and the use of force has changed considerably in the last 5-6 years. And really what it was based on is that, again, it goes back to those totality of circumstances and the without hindsight and the situation evolving. And they said, I feared for my life. Well, yeah, that doesn't fly anymore, because if you're 6'2", 230 pounds, and your assailant is 5'4", 150 pounds, doing nothing other than breaking windows, you don't fear for your life. If you reversed it, where you have an assailant who's 6'3", 230 pounds, and I'm a female officer at 100 pounds, am I justified in using deadly physical? Maybe so. And that's kind of how it's written today. So we don't abuse I fear for my life standard, as I would call it. And again, that's obviously, it's my opinion. It's open to interpretation. I bounce these questions. A lot of times I bounce a lot of my questions off of guys that are really pro-police and or girls, guys or girls, and guys or girls that really look at it a different way, whether they're cops or not. And I'm going to get their perspective on it before I start to why these things unfold or how they unfolded as it's instructed to police groups. Agency policy typically is more restrictive than the law allows. Most policies that I've read are more restrictive than what the state allows. Agency policy stand alone does not establish criminal or civil liability. Agencies may prohibit shooting from moving vehicles, which this agency does. We don't shoot from moving vehicles or shoot at moving vehicles. We don't shoot from. I'm not saying that would never, ever, ever in any case be used, but the state do not shoot from a moving vehicle or at a moving. But the state may say it just says from a moving vehicle. Both. This type of policy does not affect the constitutionality of the act or make it a criminal act, but would allow for administrative departmental charges to the moving vehicles. There's other things that we put in there as well. Don't vehicles. We also don't run cars off the road. We don't hit maneuver them. It's where you hit the rear bumper to push it off the road. That's against our policy. This type of force not rise to the level of criminal conduct, but may be viewed unreasonable by a federal court where it goes back to those civil rights issues, but still be in compliance with agency policy. This will result in a civil liability. Recognize the considerations and consequences of use of physical force by police. Misuse of force caused by extended beyond your capabilities, overreaction to the events, rushing into dangerous situations, acting on impulse, taking more action than necessary. Too much force, extend beyond your capabilities, meaning that goes to the overreaction part. You're using your ability. I mean, I'm 6'2", 230-pound guy, into the events. Rushing into dangerous situations, and one thing I preach to these police is that there's been a couple of situations where either rushing into a building or chasing somebody through the woods. I tell them, do not chase any through the woods. Do not chase somebody into a building. If they're in the building, they're in the building. At that point, we can secure the building and then get them out using other means. Don't put yourself in that situation because you don't know what's in there. I don't know what's that. If a guy runs into a building, do I know who's in the building? No. Could he be taking hostages? Maybe he is. Then going back to that tense, uncertain situation to sort of like an active shooter situation where now you have to go in. It's moving, it's moving. We don't act on impulse. I make sure you not act and base your decisions on the fact path. And I understand it's moving fast and rapidly, but you got to on the facts that you currently have and taking action when necessary. And that, again, that goes to somebody, you put somebody on the ground and just because they call you a name, you're using too much force. What can it lead to? Just to the suspects and officers. One thing I want to add can lead to these injuries to suspects and officers. A big one that has changed when it comes to use of force is neck choking. The choking case originally in New York State was the Jimmy Lee Bruce case in Wallkill. And I was able to actually talk to some of the guys that are actually there. And Jimmy Lee Bruce was ended up getting his windpipe crushed, ended up dying. And again, you take a look at today to when this happened was 86. A lot has changed when it comes to use of force. Those officers were exonerated of this, where today I seriously doubt they would be. And he was choked. He was thrown out of a movie theater is what it was. And when leaving the theater, the officer had him in a headlock And as he's leaving the theater, the officer brings him outside. The officer ended up choking him, was what happened. And he ended up choking to where it crushed his window. A car pulled up, they threw him into the back seat of the car. And then they started to try and find the other guys in it, because the other guys ended up punching and kicking the officer on the way out of the theater. And they were trying to find him. In the meantime, this guy was in the back seat dying. And it wasn't, and I was like, oh, it must have been a half an hour. So I got him up to the hospital where he had already, but that was a big one in New York, that we no longer use any sort of neck restraint. But the feds still used it. The feds used it up until probably 2010, I want to say. I went through defensive tactics instructor. They were using it. The thing also to remember, now we have changed defensive tactics that we teach. Nothing is near the head or neck. Absolutely none. Who is that we use a knee restraint on the hip, back, if depending on where the suspect is on the top, but we're allowed to go nowhere above the mid back. And other techniques that we use now, where it doesn't, it's designed not to obviously go near the head or neck, but kind of weight instead, to where the weight can then lay on the person and you can control the movement that way. So that's what has changed with use for 2020. In 2019, they actually changed it. Injuries to the suspects and officers. So with the new techniques, there's less injury to suspects and officers with the new defensive tactics techniques. Criminal liability, civil liability, departmental charges, negative community perception and relations, and credibility to the agency and law enforcement in general. Because you end up with a couple of bad apples out there, it really doesn't fare well for the other agencies out there that are doing the right thing. They are doing a good job. If you use too little force, the big one that they have here is the underestimating the suspect's abilities. Meaning, say if I really, and it says it here, given into complacency, if I'm complacent with somebody, this is how the officer gets injured. The suspect's abilities, that the toughest guys out there are the wiry guys. It's not the big guys, it's the wire guys. They're the ones that cause you the most pain. You underestimate the suspects, so you end up becoming injured. What do I mean? That means that now, in order to subdue this guy, right, bounce it back, maybe too much force, because now I got 6 guys showing up. Force, if there's a big pile-on, absolutely. When it comes to us underestimating that the suspect's ability, thinking officer should be already calling for assistance. And that's where in the academy, they start into that de-escalation of a lot of incidences that are present themselves. Failing to perceive the dangerousness of the situation. Maybe they haven't seen it, or they just fail to recognize it. And you take a look at any person you come in contact with, there's certain things that the officer does. They're going to always keep a personal space between them and the suspect. They're always going to be at a bladed position in the event that something goes bad. It's when they do other things like maybe sticking their hands in their vest, maybe getting into that personal space where they end up saying, hey, I'll take a swing. Hesitation is a big one. Because a lot of suspects out there smell it, know that they can take advantage of the officer, and thinking it happened here. That's one of my biggest to recruit classes and to even our in-service is thinking that it can here. Yes, it can happen here. Absolutely can happen here. What can it lead to? Unnecessary injuries to the officer and victims and the public, and failure to control the situation that can go from bad fast. for everybody involved. Types of force. When we're police using force, what do we mean? Amendment 4 in Article 35, physical contact or action intended to tell another person to do something. Divided into categories is verbalization. We're taught to give verbalization commands first. If verbal doesn't work, then it's an empty hand control. It's a grabbing or joint manipulation and lead to punches, kicks to gain control of someone that's being active resistant. They say that they're either fighting back or they're trying to run, which then can lead to less than lethal tools, your impact tools, your chemical sprays, or your taser, depending on the totality of circumstances, can then lead to deadly physical force. This is the force continuum that the state has had for many years now. But all of these are, the way they work is that it changes, second to second. In 1 minute, I taser out to tase somebody, the next minute, I'm back to verbalization because the threat is down, or maybe it goes back up to that point, back down. Maybe the guy finds a weapon or picks up a weapon. There's been cases here in Woodstock that, at least our guys, I know that they always seem to do the right thing. And I think that goes back to training. We've had cases where it's been going to taser, putting the taser with physical force, to going back to taser or to impact tool, because it changes. And reasonably thinking officer trained correctly should be able to recognize when to escalate it and when to de-escalate it, so it doesn't reach that point of the physical force. So. Relevant cases to the U.S. Fourth Amendment. Sacramento versus this was a and it had a passenger in the back, and they went up the roadway. They had a call for an erratic rate. The sheriff's deputy saw a rider and a passenger, and the passenger said something. The deputy rolled his window out and said, "Pull over to the side of the road." They were going the opposite direction. They said something back to the deputy and took off. So the deputy gave chase, and it went probably maybe 5 miles or so. Most chases don't last a minute. And what had happened was the motorcycle lost control, crashing, and the passenger fell off the back of the motorcycle, car running over the passenger and killing him. Again, it goes back to that. And what had happened was they sued the officer, the county or the Sacramento, and the officer ended up getting exonerated from it based on the totality of those circumstances. Versus Inyo County, this is a California case. Roadblocks, police are not, that's a seizure. When it comes to roadblocks, that's a seizure. Police, times police are ever going to use a roadblock is going to be a deadly force situation. Something warranted it to be a deadly force situation. Which, to be honest with you, in my 18 years, I have never seen. I've heard of them. I teach them as what had transpired. We don't do roadblocks, and that is any other agency. Article 35:15, use of force in the defense of a person, can defend against unlawful use of force, deadly physical force. I see there's an F there, it's got to be a P. Authorized to turn the following: a kidnapping, a forcible rape, criminal sex act, robbery, or burglary of a dwelling. To break those down, what they mean. Yes, if you have a genuine kidnap. Yes, if you have a genuine forcible rape or criminal sex act, or a robbery or dwelling, there has to be, in these cases, especially in the robbery and burglary cases, be some sort of ability for that person to cause harm to a civilian or police officer. There was a case, I'm not sure what city it is, on forcible rape. again, it goes back to, do you know what's going on? Now, some woman was screaming rape, and a cop turns the corner. It was a city cop, corner, sees the woman getting raped and ends up shooting that guy. Come to find out, it was a movie. And it didn't go over well. Again, it goes back to know your circumstances, know your circumstance when you enter. Robbery, for example. Robbery is robbery is forcible stealing. You know, to say that you assault somebody in order to gain what they had. That's a robbery. Does it reach the level of deadly physical force? If physical force is being applied, sure. But if I grab a purse or somebody down, that doesn't give me the right to shoot them in the back. And burglary of a dwelling. That goes back to Gardner, where since burglarizing, and this is a case, funny case at burglary. A guy went into a house, burglarized a house, a contractor's house. And this is a civilian case. And the contractor leaves for work. And he ended up coming back in his partner. And he ended up coming back because he forgot something. He goes in the house and there's somebody burglarizing. Well, they subdue the guy. They tie him up, cops, but in the process, they beat the crap out of him. That's a no-no. And they were held liable for that. Another big one that was recent was a Minnesota case where a guy ended up, the house was burglarized by a few heroin addicts. And they did it a couple times. And he got tired of the burglaries when he wasn't there. So what he did was he up between two bookcases and waited for them to show up. And sure enough, they showed up. And he ended up, it was a brother's sister, and he ended up shooting them. And what happened is that, and again, it goes back to castle doctrine. You know, I'm the king of my castle. But again, it only and civilians use this amount of force to stop the threat. What this guy ended up doing was shooting the guy and the brother, killing him. He shoots the girl. She shoots her in the leg. She falls down to the bottom steps, and his words now. He stands over her, and he tries to shoot her again, but gun malfunctions. She says to him, "See, you can't even shoot straight," and he malfunction and shoots her. He's young, and he's going to be there for probably the better part of 20 years for that. So just because Article 35 says it, really have to dig a little deeper into, yes, it's true, but you had better have these circumstances relating to it in order to be able to use or justify using that type of force. Article 3520 is justification use of physical force. You look these up right on New York State penal law. Justification use of physical force in defense of premises and in defense of a person in the course of her to prevent or terminate what reasonably believes to be a crime and damage to premises or a criminal trespass upon premises. Deadly physical force can be used to terminate an arson. Yes, it can. But again, if I'm the homeowner, I can't sit out with a sniper rifle waiting for somebody to, because I think they're going to commit an arson and then shoot them as they're doing it. There's mitigating circumstances, or can be used to prevent, terminate an arson or burglary of a dwelling. And again, that goes back to, yes, it's justified, but what are the circumstances surrounding it? What are the totality of those circumstances? What is the objective reasonableness to it? Is it legal? Yes, but you have these other things in place before you decide to do that. Now, if I'm in my house and somebody comes in to burglarize it at 2 o'clock in the morning and I'm home, that is just cause. Yeah, I can shoot them because I would have from my life because somebody's in my house. You know where these cases really turn sour is when, because anytime you enter into somebody's house, burglary. you don't have to have intent to steal. It's unlawfully entering a premises. So when somebody enters a house, you know where you find a lot of these things? In drunk cases. Somebody stumbles to the wrong house and they end up sleeping on the couch. Well, sometimes not. They end up coming into the house. Is it legal to do? Yeah. Can I easily articulate that I fear for my life? Absolutely. So that's when they write these things, yes, they're true, but these other circumstances in there as well. 3520 is justification use of physical force to prevent or to terminate a larceny or criminal mischief of property, meaning justification use of physical force, that is somebody stealing something. That goes back to the employees like at Walmart. They have a lot of prevention guys and they like chase the dude out in the parking lot, grab them. That's where that's where they are justified in doing that as civilians. Law enforcement as well, but that's where it's a civilian side to it. Justification use of physical force in making an arrest or preventing an escape. Physical force may be used to the extent reasonably believed necessary to effect an arrest, prevent an escape from custody, or of a person reasonably believed to have committed an offense. Again, going back to that reasonable belief to have committed offense, you have to be able to articulate that reasonable belief that they have committed an offense in order to justify using Article 3530. And that's law enforcement and civilians as well. Article 35, deadly physical force can be used for the purpose of a felony involving threat to use of physical force against a person. We know that. Felony suspect is armed with a firearm or deadly weapon. Defense or self of another, imminent use of deadly physical force, believed to be necessary to prevent an escape from custody from a detention facility. That's a detention facility, meaning to say, if you're locked up in state prison and you escape, yeah, they can pretty much at that point assume that you're going to take that much time and effort to escaping. You're more likely going to be armed. And that goes back to the case in upstate where the guy escaped from county jail and actually told his daughter that to protect them because there was another investigation going on. And I forget his name, but he was armed. He ended up shooting two troopers in a house. He shot him through a window. And ended up, they found him in a right by the Pennsylvania border. They ended up, as a matter of fact, I know the that was there. He was a canine guy. The dogs like looked down the range at and the guy fired on him. Had a handgun, fired on, missed him actually. But he ended up coming out. I don't remember his name. It's going to be assumed that they're armed and dangerous. Conduct described at the above section, but going back to that, let me go back to that for a minute. Let me say that it's assumed they are. I mean to say that if I see them, I have to say, let me see your hands. This is the police. Let me see your hands. I got to give them some indication who I am before I get there and open fire on them. This gives them the opportunity to say, okay, I'm surrendering. You have to give them the opportunity again, unless the opportunity doesn't present itself. I'm standing next to, it's not a Texas gunfight in the street. If I know he's armed and he's not complying with commands, and that's why you hear these cases, they reach in their pockets. That's related that he's about to use deadly physical force. Police officer physical force may be initially justified under circumstances, but not be used recklessly. That's kind of what I'm talking about. While attempted to make an arrest or prevent an escape from custody. Gardner, we talked about. Scott versus Harris. The officer used a pit maneuver to Mr. Harris off the roadway, and he ended up rolling a car, becoming a paraplegic. Based on a suspended driver's license. So that's why that, again, New York State, a lot of these things would never happen because we have a really good reasonable objectiveness clause. We also have qualified immunity in place to protect everybody involved. And Scott versus Harris, and this was a case that happened in 2001. It wasn't decided until 2009 because they were trying to figure out whether or not justified. So much so that when the officer went, they asked him, where did he learn the pit maneuver from? And the officer said, I learned from stories of the highway patrol. And I'm thinking to myself, did anybody not vet this guy beforehand? And it ended up being a long, drawn out case. Justification on it. The guys running that were fleeing in a car, the way New York State views it is that if you have a plate and he's out in the middle of nowhere, we kind of can figure out who it is and where he lives. And again, the totality of circumstances. For a suspended, you're going to get the plate. If it's something other than that, if the car is heading into an area, let's say I'm coming down 28, going into the city of Kingston at 4 o'clock in the afternoon at an hour. Yeah, that guy's got to be stopped. Somebody else is going to be injured because of negligence. So in situations like that, it's going to be justified to be able to do whatever it takes. And we use, we don't pit maneuver cars. We use like spike strips to stop the car. And we do have Woodstock, and we have used them, and they work perfect. Unless there's ways you got to throw it out there in order to pop the tires, but once the tires are popped, are pretty much rendered useless, and they've worked 100% of the time here. And again, at that point, you can call the person out of the car, and nobody's injured, so it works. Scott Harris goes back to the totality of circumstances. Inferred evidence or reasoning rather than from explicit dates. Limits on applications would be permitted by Article 3. Statute requires only physical force used in underlying felon. Enumerated crimes, multiple felons, the same case for deadly physical force can be used or restricted. 3531B, 123, unreasonable to prevent terminated burglary with no aggravating factors. And that goes back to what I was saying. The unreasonableness to prevent or to terminate that burglary with no aggravating factors and arsons, there's no reason to believe that lives are in danger. That's the guy where 3520 says that, yeah, I can use deadly physical, but 3520 number 1.3 says, yeah, but you'd better have factors in that in order to use deadly physical force. And that duty to intervene, and that goes back to the new law that says that you have a duty to intervene, requiring of all law enforcement to intercede where force is clearly beyond, which is reasonably, objectively reasonable in the circumstances. And even where the accused is not directly involved, in the rights violation can be held liable. The Anderson Brandon DEA was New York City, was in a parking garage where a motorcycle is trying to leave. The DEA is sort of blocking the entranceway. He goes by and clips the mirror. And he ended up, another officer, DEA agent, was further up the parking garage, and they stopped him. And to where an altercation ensued, they decided to arrest the guy for obstruction, and then this starts. Well, there was a supervisor there, and he did nothing to stop it. He then was held liable for it, as long as them as well. Let's see what else we got. Do you guys want to like stop for a second? Because I'm throwing a lot at you.
Yeah, there's definitely a lot coming up. Thank you so much for taking this time and going through all of these slides one by one. And I know that this is work that normally takes like a few days for you to go through, right? Like this is actually a workshop that you're kind of moving fast through. So I definitely understand that there's many things that you kind of have to like fly through to get us this information. I'm also curious though, if there's like a part of this conversation, like in the beginning, where you sit down with officers and you kind of like talk to them. I understand this isn't an implicit bias training. This isn't a de-escalation training. This is sort of allowing them to understand. Basically, it sounds to me what they're allowed to, I hate to use the words get away with, but that's kind of the quickest part I can. But like the part where they're actually sort of given like I don't know if there's like social and like relational work that goes in, like where does this particular training come in the in the timeline of police training? And like I know you mentioned that this was written by the forefather or the grandfather of this particular conversation, or what? I missed that part a little bit in the gentleman's name. And so like I'm just kind of wondering, like, where does the part that like humanizes this, aside from anecdotes, kind of like if we were just walking into this room and you're like, all right, we're going to sit down and we're going to talk about all these penal laws and we're going to go through all this stuff, but like we're here because we kind of really need to get clear about how we treat humans while we are arresting them. So like that's the part I kind of want to hear and understand a little bit more, as far as just like how much these conversations of humanizing, because we understand we live in a society where like guilt determines justification for certain activities, right? So we look at this and we say, well, if they're guilty enough, then this is what you can do. And if they're not guilty, you better be careful. And we need to be careful to protect the people and the police. But like there's levels and tiers here that like kind of waver right through this, because we're giving these officers have double indemnity pretty much because of some of the policies that are in place to protect them. And we as citizens are kind of wondering how we can move, and particularly with the governor's mandate, beyond like baseline federal policy and federal like baseline bottom lines and state bottom lines, but to begin to create with our communities what works for with us and for us, right? Like this is an awesome process to get to participate in. And I know it's shortened. So the part I want to know is like where the humanizing part comes in a little bit. Does that make sense?
Yeah, I understand. We kind of do when it comes to instruction. We'll put, as far as the academy setting and an in-service setting as well, is that we take use of force and we'll also mix it in with our implicit bias training, and also put it in with mental illness training. So as I give this presentation, let's say in an academy setting, right after that, somebody else is doing an implicit bias, and right after that, somebody's doing a mental illness, and it kind of goes schedule that way. So as these recruits are learning, we sort of mix them together,
right?
So they understand that yes, these rules place when it comes to objective reasonableness, but what am I dealing with? Am I dealing with an emotionally disturbed person? And here are the symptoms of an emotionally disturbed person. So you have to decide how much force you're going to have to use an emotionally disturbed person, as opposed to de-escalating that situation. De-escalation training is another one they in the academy. That
absolutely,
again, using bias and using what you learned in Article 35 and using what you learn in penal law and so forth. You got to be able to make these determinations based on what you learn and based on what you were tested on, because ultimately what it comes down to, that if I'm not able to recognize or implement what I learned, then yeah, I'm going to be held accountable based on the objective reasonableness and equality of immunity.
Right. And so then
I was taught implicit bias, and I was taught how to do situations, and I'm going to be held to that standard. Their books, their notebooks
right.
in the academy, they're all legal documents. They can be sequestered.
Right. And so my next question, and I'll let others ask if it's still open. My next question is the de-escalation training follows the implicit bias? And I mean, the implicit bias and de-escalation, that follows these, because this is like a penal, this is like really looking at the laws and then you break it apart? Or do you do the implicit bias and the de-escalation prior to this training?
And because you're breaking up, I think I got what you said.
Well, is
so
it
what we
before or after?
I'm going to just I think what you ask is that when do we deliver the implicit bias training and when do we deliver training, as opposed to when they get this? Is that what you said?
Yes. In other words, does this come before or after implicit bias and de-escalation? At least the implicit bias, right? Like where are they flipped?
Typically, what we do is that we'll give them penal law, criminal procedure law, use of force, and then we move on to implicit biases and mental illness and our de-escalation tactics. Which then brings us right to defensive tactics, which they do 8-week defensive tactics training. So they set up scenarios. So as they learn this stuff and they pass the written test, we'll set up scenarios using some cops. Actually, you have a couple of cases we're able to use college students, and they act as actors, and they come in. Here's a scenario. What are you guys going to do? And then we have state for to critique on some of the things they did right and wrong, and then from there we do other additional training in the academy. But we try and keep our penal law, our de-escalation, implicit bias class moved right to defensive tactics, moves to scenarios, and they're tested on those things, on their practical for de-escalation, defensive tactics, and they're also their ability to do right when it comes to scenarios. Is that are they doing the right thing? They graded on it. There were actually some cases where you have to write, I don't know, I've written 2-page documents on what they've done wrong to where they can be thrown out of the academy.
Mm-hmm. And this is an interesting thing as I read this as a brown person in America, right? I have a certain context. And so as you're going through these, like there's a lot of questions that I have in this, right? And I know this is all shortened down, but because I have the actual context, I'm able to approach it with the questions of like, how am I being cared for, and how's my brown son, right, being cared for in conversations like this, or an LGBTQ, right, a human, a young human who's like out there in the world, right? So when we look at this, we have a certain perspective, but when like implicit bias comes after these kind of penal laws, like everyone who's looking at these penal laws has a different approach to how they're looking at them as they might if they had had an implicit bias like training and workshops and prior to this. Does that make sense? Or how do you feel about that scenario?
What we typically, there's another class that we also do is cultural diversity. And we do a 2-day training on cultural diversity that's actually been from a captain in African-American captain, brilliant guy from New Paltz, SUNY New Paltz, and doing it for years. And he also tests them on their cultural diversity before he's done with the class. They have to pass test, written test.
And this happens prior to this training.
This goes right, and again, that's another one that goes before defensive tactics, before we start defensive tactics.
But right, so none of it is prior to these penal law trainings. The penal law comes first, and where comes the aid. Like that's what I'm trying to understand and determine.
Well, it really goes and depend on how they build the schedule. He doesn't give. They kind of want them to kind of go out a certain way, but there's no rule saying you have to. We come it that way at Ulster, where we're going to give them the law first, how they're applied, and then give them the things to say, okay, you got the law, you know how it works. Here's what's happening in society. How are you going to be able to balance that out without being reckless? Keeping it in check.
Thank you. I appreciate that answer. Thank you.
Not a problem. Not a problem. Actually, I appreciate all your questions, because it seems when we go through these meetings, you're very vocal. That I appreciate. Honest with you. And then you added to actually see what we do at the academy, anybody.
It's from the police academy. It seems like.
Any other questions so far?
I have a question.
No.
This maybe you can answer this or the chief. Let me turn my video on. In Woodstock, when there's been incidents where there's use of force, is there some kind of tracking when that happens? Does Woodstock, town of Woodstock, do we track that? Is that documented?
Yes, we have a form that's required, besides the basic incident, we have a special form that they have to fill out when they use their firearm, which we've been very, it's only one time in my career we've ever had it and it did not get hurt. Anytime they use their taser, their pepper spray, and now we included anytime they use physical force, it has to be part of the reporting process also. And literally just about a week ago, I just from PCGS, that they also want to have a monthly report, when they even display their firearm, their taser, or a baton or the expendable.
Thank you.
So there's not only checks and balances each police department, but also the state is going to be reviewing the use of our force also. So just started it as November 1st. Any incident from November 1st on is going to be reported.
Thank you.
Actually, use of force or the display of a weapon.
I had a question. Oh, go ahead, Anula.
Thanks, Tam. Just a quick question, the relationship, so in preparing for in-depth questions next week, can you talk a little bit about how the penal laws work in relationship to town police policy? So we've got penal laws that have to be addressed, but then we've got town policy that that's also in place. Is there a brief explanation of how they relate to each other? Is one just clarifying the other?
The way the policies pretty much get written up is, and depending on what agency you work for, some are more in depth than others. They all have to still follow what New York State says. Just reading through our policies, they do follow what the state says, and then also what some of the things that I spoke about today, the new policy has that to where, like, say, for example, and I'm answering your question correctly, is that when it comes to, say, burglaries, when it says Article 3520, can I use deadly physical force for somebody backing out of a window? Well, no, because of the objective reasonableness. Those things are in the policy. And that's what the officer is agreeing to when they sign that they receive the policy.
Okay, so there's penal law training
that are taught, and this is taught every year as an in-service to our guys here.
Okay,
thanks. Did that kind of answer it, or? Yeah,
so the Human Rights Commission did enhance a policy some time ago, and so I just wanted to kind of understand for and bring out to the public that we do have these penal laws, but we also have local Woodstock police policy, and so both become very relevant for people to read and for us to discuss.
Our policies would have to be more restrictive than what the state requires.
Yep.
If we have policies where, so we're going to have our typical Article 3505, Article 3530. We're going to have anything that's going to be more restrictive. It can't be less restrictive.
On slide 32, you talk about misuse of force and possible reasons for misuse of force. A couple of those I have questions about the resources that can be offered to people and under what conditions must be offered to people. Two of those are impulsivity or overreactions. How are those handled when that's identified as a misuse of force?
When we get a misuse of force through disciplinary action, if I take 105 105-pound woman, and I don't know, I'm gonna spitball. Let's say I take a 105-pound woman and I don't particularly care which, and end up breaking her arm. I mean, I'm being facetious. But, you know, does that require a disciplinary action? Absolutely. Absolutely. And there's other things as well. If I don't know, if I try and subdue and I have them subdued and I'm cuffing them up and I spray them in the face with OC spray, that's disciplinary action. And the officers on scene that's this are required to tell the chief in writing, tell the chief. Not just
So
tell
that's
him.
under the duty to intervene, you're saying?
Yeah, that's a duty to intervene. If an officer is doing something outside of the scope,
Mhm.
then yes, they're going to be held responsible for it. And I say that, and then a better example is that if somebody's already roughed up, why am I spraying them or why am I tasing them? And I say that because 18 years in law enforcement, I've seen it.
Mhm.
I've seen it, and it doesn't make me very happy. I've seen it with other agencies, not the agencies that I've worked for, but I've seen it with other agencies. But it wasn't until recently that they came out with the new rule that you have a duty to intervene.
Mhm.
And it goes back to the person you're subduing. You know, if I'm doing an EDP, just because I don't like him, that does not give me the right to spray him with OC spray or tase him. He's already up. He's already secured. That's it. You put him in the car and you seatbelt him in. And that, again, that's taught in inserts. I hope that answered some of it.
Yes, thank you.
Any other questions?
Other questions? It's coming right up till the end of our time. Anyone else has a question, feel free
Rachel,
to.
can I ask you something? Are you still there?
Rachel. Hold on, just give her a chance to unmute.
Sorry, I'm muted.
Okay.
I'm back.
For the future, I like to bounce a few questions off you before I give this training to recruits. I like to add you to my people that I contact.
Absolutely.
Okay.
Go
ahead.
I'm very interested in we have, Woodstock has a very I've known Clayton, the chief, for 35 years at least. We have a long-standing community police force, and we really do we're very fortunate as a small town in the Hudson Valley, right? To have such a committed force. We also have a lot of members of our force who are who don't know us. We have a few who do, right? Maybe 4 on the force that we really know. And so a lot of community members are left feeling vulnerable as the community itself changes drastically. And so do the police officers and the does the force. It sort of changes, even though there's a few that we wave to and know when we are passing them. And so as we look at these the reinvention committees that the governor's mandated, and we know that there are different needs in different communities for like levels of addressing systemic racism, implicit bias, othering of any societally disenfranchised humans, and we've been given this incredible opportunity to reinvent this process, right? And there are things that have been identified within the conversations as we've been going on. And what we're looking at now, like what I'm seeing, is that we have the opportunity to kind of really support not only the community, but the officers in being able to focus on things that are really needed of us, right? Like there's a lot of things that fall into the hands of the chief and other officers that if they weren't in their hands, they could be addressing some of the other issues that that kind of could use some police oversight. And so as we're going into a reinvention committee, reinvention conversation, and we're now having the opportunity to speak with an educator, like I'm really thinking about these things, and I know it seems super subtle, but to me, something as simple as moving when certain trainings are happening could like really be effective. And so my mind looks at the intersections of where our community and our policing meet, and where we can actually relieve our officers, and also, you know, maybe like reinvent how law enforcement works in this little town. This is Woodstock, and people watch us from all over the world. And in a conversation like this, like we could be a model changing, we could be supportive in that process if we really looked at how to do this in like a big way. And I'm of course a radical, and I want to see like super big change right away, and I'm intense and all those things, but we really are at a baseline time where we could be working from the ground up. And as an educator,
Yeah,
like I'm really interested to hear what you're feeling through this process.
Yeah, oh yeah, absolutely. And that's why I mentioned I'd really like to pick your brain on certain topics, because I you're pretty knowledgeable when it comes to your area, and it's something that I can relay to recruits coming out of the academy. Absolutely. And I know that our little here in Woodstock, I know that we all know that the community has a positive approach to us. They seem to like us. And that we appreciate, believe me, 100% we appreciate. But do we have an opportunity to change a lot of things that should have been changed? Absolutely. That's what pick your brain.
Wonderful. And I'm really looking forward to this committee getting to pick the brains of our 3 local officers who have known us for a long time, because they know us. And I'm interested to learn a little bit more about how they're perceiving this, and how they're relating to being updated, or if they have a desire to join this conversation. I know they're all overwhelmed. I mean, we're all overwhelmed with how much work we're holding in wherever we are. But as we reach into the community, I'm looking forward to meeting more of the officers that are on the staff, and also really hearing from our long-term officers. You know, Greg's been here for many, many, many years, and he really knows us. Kevin grew up here in this town, and John has made like a really strong effort to become a part of this, to stay a part of this community, even while he's not actually living right here. So we have a lot of opportunity to make these shifts, and it just, I think it's, as hard as it is, it's also important.
Not impossible. These changes, obviously, I feel can be made. They're hard, yeah, but they're not impossible.
No, and I think in a lot of this work, we've been identifying that family needs some uplifting, right? Like family carries a lot of what Woodstock produces for police, right?
I
So
don't know. I believe. No, go ahead. Go ahead.
that was it. I'm backing out, and we're getting, it's already 5:30, so I don't want to hold anybody too long.
Family in Woodstock, I don't know what we would law enforcement wise. I don't know what we do without you guys. You guys are a huge help.
So Shamsi, I see you in the if you have a question, I think that's what we're doing now, was taking some time to answer some questions if you had a question. And you want to keep in mind it's a little after 5. I'm sorry, I didn't change my clock. A little after 5:30. But if you have a question you'd like to ask, go for it. Set to end at 5:30. But we'll be back next week.
Sure. I just wanted to say, as someone who is neurodivergent, I have cognitive issues. For me, this PowerPoint, I can't process it. I still feel that I have something to say if there is an opportunity to dialogue with whoever it is that is making the changes.
Yeah, I don't see why.
Yeah, I believe, Shams, that what's happening here, we've been in general up until today, we've been in like working group process as a committee to try to work through reaching out to the community so that we can continue to function in the process of like learning how the what our police go through, like what is their training, what are the processes that they are working through in order to, relate to the rest of the community, right? And so we're going through like all kind of different levels. Today was this is where we have a use of force, an outdated use of force policy in Woodstock, which the chief has just adopted the federal use of force policy. And so this is us getting a little bit of a chance to understand how the use of force policy is trained, although it's been brought down into a really short amount of information. And so to sort of get an idea of what that process looks like, we've been riding along this PowerPoint. What's happening in the actual local conversation is may move back to working group status soon, and hopefully next week we can actually talk about the use of force policy as it's being adopted, and it'll be a little bit shorter and easier to digest.
This is the updated one? This is the updated one, or this is
No, this is a training he's sharing with us in an hour and a half what he normally puts through a 2-day workshop as he's training officers. But we actually next week should be looking over the actual use of force policy that Woodstock is working with. And so this is giving us an idea of how that training process works in a super short, super tightened, this is not how they take a lot more time to process.
Time and videos and other things with it. Let me ask this, Ashley, is the policy or Chief, did you give the policy to Ashley to put up on the committee website so folks could see?
I just want everybody to know that that the policy that we use now is basically what Rob teaches in the academy or in service. Our policy is based on what he's teaching right now to recruits.
But is that on the, can we get that on the website, on the committee webpage?
I have the most recent version. I can put it on the website.
Okay, so that will go up. I want to thank everybody. Thank you, Rob, for talking us through some of this. Appreciate everybody. You're all welcome to come back and meet us as often as possible. And we will pick back up next week and have some more time to ask some more questions around this and around our own and the way it applies here in Woodstock and the most recent policy. Thank you, everybody. Have a good night.
Rob.
Thank you.
Thank you, Reggie.
All right, thanks. Bye-bye.